Dr. Murray's present with counsel, Mr. Chernoff, Mr. Flanagan, Mr. Gorgian, and Mr. Pena. The people are represented by counsel, Mr. Walgren and Ms. Brazil. All the jurors and all the alternates are present. Good morning, ladies and gentlemen. Hopefully you had a productive day off yesterday. And once again, thank you for accommodating us. In the time when you were off, counsel and I discussed exhibits and jury instructions. Let me advise you that the following exhibits have been received in evidence. And you don't have to feverishly try to write down everything because you're going to get an exhibit list. With the number of exhibits in this case, we can't expect you to memorize each exhibit. So you're going to get an exhibit list, and that exhibit list is going to indicate every exhibit that has been received in evidence. You are going to receive a substantial number of exhibits in the jury room when you begin your deliberations. Other exhibits will not be presented to you at that point in the jury room, but will be available on request if you'd like to see and examine them. Some of the exhibits, which may contain forensic matter, for instance, or medication, for instance, are not, as a matter of court policy, brought into the jury room unattended. I'm sure you can understand that. But they're available, and if you want to view them, you just send us a little note, and we'll have one of our bailiffs bring in that particular exhibit or exhibits. The important thing is you'll have access to any and all exhibits that are received in evidence. And the exhibits received in evidence are Peoples 1 through 53, 56 through 226, 228 through 229, and 239 through 244. The defense exhibits received in evidence are A through J, and then L through SS, BV through XX, ZZ through triple X, quadruple C through quadruple E. Some of you were smiling. A quadruple G through quadruple N, and then quadruple P through quadruple W. Once again, you're going to have a list, and it'll be pretty clear what you're receiving as exhibits and what you are not. If you have any questions, you know where to find me. At this time, ladies and gentlemen, I'm going to be providing you with the legal instructions that apply to this case. Each of you should have a copy of the jury instructions. Do all of you have that copy? It was provided to each of you, and all jurors are indicating the affirmative. As I'm going to be telling you in just a few moments, the law requires that I read the instructions to you in the open courtroom. We feel that it's appropriate to have each juror read along with me. So you have your own personal copy. You receive the master set of instructions in the jury room during your deliberations. You also have your own personal set, which you review at this time and during your deliberations. And it's your personal set. It's yours to keep. And you can write on your personal set. You can make notes or comments on it if you'd like, both now and during deliberations. My suggestion is at some time you may want to put your seat number on your personal copy, so that way if it gets put down, you'll know where to find it. The important thing is you can feel free to write anything you'd like on your own personal copy since it belongs to you. Let me indicate that while I have gone over these instructions on many occasions, there still may be some typographical or grammatical errors. May I suggest that you have a pen handy so that if, as I'm reading it, it becomes apparent that there is such an error, you'll be able to correct it. It should take about 28 minutes and 14 seconds for me to read these instructions to you. That's going to vary by a little bit, but it'll take just about a half an hour for me to read the instructions to you. After I do that, we'll take a break. I think you'll probably need it. We'll take a little bit of a break, and then the attorneys will begin their arguments, and I'll give you a little more information about it. So if you would turn to page 1, which is always the best page, page 1 of the instructions. Post-trial introductory series. Members of the jury, I now will instruct you on the law that applies to this case. The law requires that I read the instructions to you in the open courtroom. I will provide you with the written master set of instructions to review in the jury room during deliberations. In addition, I have provided each of you with a written personal set of instructions to follow at this time and review in the jury room during deliberations. While you cannot write on the master set, you certainly may write on any personal copy. The instructions that you receive may be printed, typed, or written by hand. Certain sections may have been crossed out or added. Disregard any deleted sections and do not try to guess what they might have been. Only consider the final version of the instructions in your deliberations. You must decide the facts in this case. It is up to all of you, and you alone, to decide what happened, based only on the evidence that has been presented to you in this trial. Do not let bias, prejudice, sentiment, sympathy, public opinion, or public feeling influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, the defendant, or the alleged victim, based on disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explained it to you, even if you disagree with it. If you believe that an attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be defined specifically in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not defined specifically in these instructions are to be applied using their ordinary, everyday meanings. Some of these instructions may not apply, depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you have decided the facts, follow the instructions that do apply to the facts as you find them. Do not conduct any research regarding this case on your own, through another person, or as a group. Do not investigate the facts or the law involved in this case. Do not use a dictionary, a Bible, the internet, or any other reference materials whatsoever with regard to this case. Do not access any internet site, including but not limited to any search engine site, such as Google, Ask, Bing, etc., or any social networking site, including but not limited to Facebook, MySpace, etc., or text or tweet, or otherwise post any messages, or access any blogs regarding any aspects of this case or the persons identified in it. Do not listen to, watch, read, hear, or otherwise have any contact with any television or radio program, book, or newspaper or magazine article regarding any of these subjects. Do not perform any experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. If anyone contacts you about this case, wants to discuss the case at the time, or offers you the opportunity to discuss the case at a later time, attempts to offer any opinion on the case, or otherwise tries to influence you in any way, immediately cease such contact and immediately notify the courtroom staff. You have been given notebooks and may have taken notes during the trial. You may use your notes during deliberations. The notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement about the testimony and stipulations at trial, you may ask that the court reporter's record be read to you. It is the record that must guide your deliberations, not your notes. You must accept the court reporter's record as accurate. Please do not remove your notes from